is no bright line. People say, oh, it doesn't have to be 14 notes or something like that, or 3 seconds, but there are no bright lines there.
In a world gone mad, there's 21 kilohertz.
Well, we waited so long to get this episode out that the Marvin Gaye Estate, who sued Robin Thicke and Pharrell for copyright infringement by, in their opinion, stealing Marvin Gaye's song that he wrote and using it in their song without getting a license, has made it all the way through the courts, was appealed again, and finally a decision was rendered, which you can learn at the end of this particular episode.
So who are we talking to, though? But who are we talking to?
Good point, yeah. So... even more importantly, we are talking to the witness, the expert witness hired by the Marvin Gaye Estate, a musicologist.
Judith Finell.
The woman is a savant when it comes to music and notes and notation and canter and beats, and provides insight into the inner mechanism of a lawsuit, as well as understanding how music is structured and the financial value of music.
So Jeff called me up and said, let's do a piece about a musicologist. What is a musicologist? To a layman, what would you do?
Well, musicology is a German discipline to do with the study of music, just as the word would be defined. In practical terms, you would consider me in the work that I do in copyright as more or less a forensic musicologist, which doesn't exist in any academic music department, in the sense that it's not something that one can major in within a subfield of musicology. So musicology is really the study of music, and often musicologists are focused in one era or another, or one style or another.
Well,
but
let me stop you for a second. You mentioned you were kind of a forensic musicologist. What would be the definition of forensic? That word is a very sexy word.
Well, I mean, basically, I mean that I'm applying my musical knowledge and my ability to dissect and analyze music and all forms of sound to the legal process of copyright protection for intellectual property.
So what musical instrument do you play? You must have a background in something to be a musicologist like this. There's no way you don't play an instrument. What do you play?
Oh, thank you. Well, yes, I was drawn to music because I was interested in the performance and composition of music, not because I wanted to study other people's music initially. So the simple answer is yes, I'm a pianist by training, and the study of music and the analysis and theory of music came later in my training, where I became more interested in understanding music as an entire field rather than just applying my own musical interests independently. So I turned away from performance.
What did you play? What instrument did you play?
Oh, I played piano really all of my life. As a child, I actually was a performer on the radio quite often, and was found at a very young age to have perfect pitch, and this led to a lot of musical opportunities. And so all of my undergraduate and graduate work first it was in piano performance, and then I changed it to musicology as I advanced. I was much more interested in the study and analysis of all different kinds of musical forms, including sounds such as sound effects and all, any sound-related property.
Judith, you said you had perfect pitch. What exactly is perfect pitch?
Well, it's a fairly rare quality. It's basically the ability to recognize, without any prompting, to recognize a pitch, a tone, and recognize what it is. And I think of it as a form of musical memory. So if I hear musical notes being played, I can say, oh, that's an F sharp followed by a D followed by a B flat, etc. I can tell you exactly what notes they are without any third-party reference.
So that's fascinating. You know, I know some people that can read sheet music, but they can't play an instrument. And then I know people that can play an instrument, but can't read sheet music. Can you do both?
Oh,
you,
yes.
Like see the sheet music and hear it in your head and play it?
Yes, I hear them fully. I mean, part of that's my training and part of but because of the perfect pitch, I actually hear the actual notes instead of just what you call relative pitch, which is just seeing the relationship of the notes on the page all at once. So often I'm studying for a case I'm about to testify with, and I'll be sitting on a plane, studying all the music that I'm about to discuss. And it's every single time some person sitting next to me is staring at me like I'm totally crazy because I'm looking at this thing that they don't understand. All they can tell it's music, and I don't seem to be listening to anything on any device, and I'm clearly studying it in some way. So, but that's not. I mean, I'm not in that way. Other musicians would do that too. I've heard of classical pianists like Rubinstein and all who used to study music like that on planes before he'd go and play in Carnegie Hall and places like that. So part of it's training and part of it's the perfect pitch makes it really specific so you actually hear the sounds that are represented on the page.
So wait a second. There's this case between, if I recall correctly, Chuck Berry and the Beach Boys, where I think the Beach Boys were accused of using something from Chuck Berry and Surfin' USA.
Right.
But there's so much going on in that song, harmonies and vocals and instruments. When you sit and you listen to a song like that and you hear all this other instrumentation going on and all these harmonies and bells and drums, are you able to sort of in your brain sort of isolate these individual parts and you can sort of zoom in forensically on the section that has been stolen or used or is infringing on the other work?
Yes, the answer is yes, I can, but it took a lot of training to do that. One has to teach oneself or has to be taught that type of discipline because you're right. And that's very important to know how to do because then you have to teach a jury how to do it. So say you're playing a recording of a Beach Boys song that has singing going on and electronic instruments going on, guitars, backup singers, bass line, drums, everything's going at once. And you're trying to point out this one little instrument that has the same melody, the flute, or one of the 3 or 4 singers that's singing the same vocal line as on another song with a lot of other conflicting music that's also occurring simultaneously. That's the challenge, is to educate a judge and jury to the point where they can actually focus in and understand what you're trying to explain about similarities between musical works.
So in a practical sense, what is your role you end up in courtrooms, I assume. And, I have this image of you sitting next to the judge and, like a Law and Order episode. I assume it's exactly like that, right?
All right. So, I have a firm of a team, really, of musicologists with similar background to my own that I've formulated over the past 25 years in business. And they're an extraordinary team of talented musicologists, most with doctorates and many on the faculty of esteemed institutions. And so they all have some form of similar training. There are differences between us, but we work together and we would be hired to do any number of things. One, if it goes to the extreme of actual litigation, that a dispute has really broken down its negotiation powers and the only way to resolve it is in the court of law, then I'm asked to testify and determine and explain to the powers that be, whether judge, jury, or both, what the musical resemblance is if I'm been hired by, and my opinion is that there has been copying, and that would be hired by what you would call the complainant or the plaintiff.
So is the sort of person that would hire you, let's say it's a songwriter that writes a song, and all of a sudden they're listening and they hear another song out there and it sounds like their song, and they say, wait a second, that's my song. They stole my song and they've used it. So they go and they hire a lawyer and they file a lawsuit claiming this other person stole their song and used it in their own without getting a license like they're supposed to. And then they put together a legal team of expert witnesses, and then you and your team get called, and then you end up on the witness stand, and it's your job to sort of forensically analyze and pull this thing apart and prove that this first person's song was stolen?
That's right, yeah. That would be an example of one side that would hire us. Another side would be the one who got the call and wants to defend him or herself, saying, I didn't do this and I need you to disprove it. So we're hired by either side. we still, we only testify to what we believe is musically accurate and true. I mean, I don't say anything just because that's the side that hired me. Often I turn down cases. A large number of cases I turn away because I'm not going to be accurate in verbalizing the particular position of that particular potential engagement. Because I find there are too many similarities to believe that it wasn't copied, or vice versa. I find so many similarities that I believe it was copied. So it depends on which side calls first. But the idea would be, if I don't feel I can truthfully testify under oath and musically do so, then I won't take the case. But I'm often hired by attorneys on either side who have a case that's been posed to them by a potential client. And our job is actually to appraise the case and evaluate the strengths and weaknesses and tell them how strong a case they have or how big a case the opposing side would be able to pose against them.
So I have to imagine the other side has a musicologist as well, just like you. And so there's only so many ways to dissect something, right? I mean, I'm not a musician. Lord knows I've tried, but I'm not a musician. But, imagine a chord progression, and if I'm saying something wrong here, I'm sorry, but like F sharp to G minor to A to C to B. And if that's what it does, isn't that what it does? What can the other side possibly say back to you? Because that's what it is. What's their argument back?
Well, the biggest, if it's on that side, if you're on the side of the plaintiff, for example, in the scenario you just described, the other side would probably, depending on how skilled that person is, but of the handful of people I'm usually against, they'd be very skilled, and they'd either come up with what's called prior art, which means they would find music that preceded both of the songs at issue that resemble them in the same way. And they'd say, well, look at this chord progression, and you can find it, 50 years ago in these 10 songs, or look at this series of notes, or these lyrics. Depends on what you're saying is similar, but it would be the job of the opposing expert to trivialize it if that's the defense's position, or to make it clear that it's not original with either artist, for example. And so there are various ways.
I have to imagine there's not a lot of people like you on the planet that do what you do the way you do it for who you do it for. And there's probably a limited number of people that'll be on the other side. There's like a you on the other side for the defense or the plaintiff, right?
Yes, there's about 4 or 5 of us. They're very, very few. I mean, you have to realize that when a case breaks in the news, like Blurred Lines or other big cases that are in the news these days, everybody comes out of the woodwork and claims he or she has the knowledge that it takes, and they all become so-called musicologists. But the truth is, it takes a federal judge to qualify you to accept your testimony, and it requires pretty strong academic credentials and a lot more than that. So
would you mind if we took a second, and could you go back and explain what the Blurred Lines case is all about, actually?
So the Blurred Lines case, was a case in which the Marvin Gaye Estate, since Marvin Gaye is no longer living, but his estate felt that his song, which was entitled "Got to Give It Up," had its copyright infringed by a song that was sung and produced by Pharrell Williams and Robin Thicke, entitled "Blurred Lines." And it was a very big selling song, in, I believe it was 2014. It was perhaps the largest selling song of that year. And they felt that, the Marvin Gaye Estate felt that Gaye's song had been infringed or copied. And so it was,
and your role in that was to define whether it was infringed, whether there was a copying going on, whether it was the same music in both songs.
Exactly. My role was to explain what elements were, in the legal terminology, were substantially similar between the two works. Because in any of the works, if you take a slice in time of the recording of either work, for example, you've got, 10, 15, 20 things going on all at once. And it may just be one of those 15 things that is similar between the two. And you've got to teach the judge and jury to kind of screen out all that other noise and focus. And that's the big challenge of my work when I'm testifying.
So could you take us forward and walk us through this at a very detailed level? And this is just fascinating. So the phone rings, and it's Richard Bush, the lead litigator from King and Blue, and he calls you up and he says, "Hi, we're looking for an expert witness, a musicologist, to be involved in this case." What exactly do you do next? How do you even get started? What sort of research do you actually do?
Well, yeah, of course, I can't really reveal the actual discussions or anything, but certainly the case, which is now on appeal, Mr. Bush and I have been speaking pretty widely on it, so I know I am permitted to talk about at least what was said in court. But basically, the real thought process is this original to begin with, or is this so commonplace that there's really no way to assert that it had to have been copied?
What exactly is commonplace? For example, there's a band called U2, and they have a song called War. And there's this very distinctive snare drum intro to that song, but frankly, it's just someone hitting a snare drum. So is that commonplace, or is that specific to that song? Or if this is not a good example, can you provide us an example of something that you think is commonplace?
I mean, I can look at a series of notes which might be written in the blues, but I can see that actually that series of notes is very common in, 1960s surf music. And because if you can divorce it from the way in which it's produced on a recording, you can see that that's a common series of notes with a certain style of rhythms and a certain style of chords that support it. So we go looking through, Beach Boys and other kinds of, California surf music. So really our job is partly to identify, but also segregate the properties. And we may say, that series of rhythm, of that series of chords is very common in hymnals in the 1600s, and we go to our hymnal area. So a part of it's knowledge and part of it's research.
It sounds like a lot of what you do is kind of like the feeling for something. It's like, well, it sounds alike, so it must be alike, but you have to quantify that feeling. I mean, is that the way to look at it?
No, the work we do is totally objective. It's really concrete. It's exact pitches, it's exact duration of each pitch, it's exact harmonic support for that, and exactly how the harmony is spaced. In other words, the chord has 3, 4, 5, 7 notes, depending on the genre. How are those notes spaced from one another? No, it's very concrete.
So when you were presenting to the judge or the jury, and you were trying to make your case of the infringement, was there a moment where you saw the light bulb go off over their heads, where you said, look, it went, da, 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 da here, and all of a sudden you could see the realization wash over them, and you're like, aha, I've done it, I've made the point? Well,
remember, there's more than one juror there. Some of the light bulbs you could see in that way, but not all, and you're not sure really what they're thinking, or if they're sitting there, thinking about what they'd rather be doing, etc. But, it's hard to say, but I think there are a few things. One, the judge did not permit us to play Marvin Gaye's final recording of his song because there were items, because this was the legal problem the other side used as their defense. Marvin Gaye's song was released in 1977. The law changed in 1978, 1 year later, to say that you could submit a recording as what you call your deposit copy. But he wasn't permitted to, so he had to rely on the lead sheet. And this was a huge challenge.
What is a lead sheet?
All right, a lead sheet is a skeletal representation of a song. And before 1978, if a songwriter wanted a copyright, or the songwriter's publisher wanted a copyright in the composition, I'm not talking about the recording, which is a separate copyright and always has been. But the underlying song has its own separate publishing copyright. It's called the compositional, the underlying composition. And the lead sheet represents some aspects of the final song that you might hear on a recording. So there's a gap in between what the lead sheet might show. It may show no drum beats. It may show no bass line. It may show typically it shows the vocal line with the main words and the chord symbols. And that's just about it. So anything else you hear on the recording of that song, like the drums or even a guitar riff and all other kinds of instrumentals, it might not even be on the lead sheet. So it may not even be part of the copyright protection. Depends on when it was written.
Interesting. Sorry to interrupt you, but that's just fascinating.
And this was a huge challenge. So the lead sheet did not represent all the similarities one heard on the recordings. And the judge forced those recorded similarities that were missing from the lead sheet to be eliminated. So that what the jury could hear was the complete professionally produced Blurred Lines recording by Pharrell and Robin Thicke, but they could not hear Marvin Gaye's recording.
That's nuts.
Well, this was the biggest challenge I've seen in any copyright case that I've ever testified in. That's the only time I've ever seen this done. So the judge said we could play Marvin Gaye's recording, but only if we stripped out anything that wasn't in the lead sheet.
Oh my God!
So so the jury wasn't hearing the complete reality in that way. They were only hearing a portion, and this was the biggest.
So you had to explain a song almost. You had to verbalize a song to have someone recreate it in their own.
And did you go in and remix the
We
thing?
remixed it. We were allowed to remix it for this purpose.
Oh my God.
And we made short little, they were only allowed to be a couple seconds long each. So the jury had to kind of grasp it. But I was allowed to play the keyboard in the courtroom and illustrate a lot of the concepts and the defenses and disagree with the musical defenses with my musical keyboard. And so I was able to help the jury guide them to listen what you would think of as listening with understanding.
So what happened with Blurred Lines?
Well, Blurred Lines was the word that I coined in Blurred Lines in my reports and on the stand was it had a constellation of similar features, meaning it had several similar, near identical features that all coincided in a very similar framework in the two songs, and made it really undeniable that the one song had been modeled after another. And it wasn't just a feel. The common propaganda out there that's being, stated is, oh, it's just a vibe. It is not just a vibe. It's concrete compositional similarities of pitch, rhythm, placement, etc. And it coincides so much that it's close to almost 100% of the duration of Blurred Lines. We found at least one, but usually 2, 3, or 4 multiple features all in the same bar coinciding and overlapping. So that's why I called it a constellation. And that's unusual. I don't use that word very often at all in these cases. Sometimes all that's similar is the hook of each song or a guitar riff or something else that's more isolated. But in this case, it was constant. It was covered over by a lot of other skillfully, done material, but it was constantly, the similarities were there and really undeniable. It was way beyond coincidence.
What did the other side say?
Well, they did the best they could to minimize that, and do their best. And they had, a lot of ability and resources to do that with. But in essence, in the end, they didn't find a single other song. And I'm sure they spent, hundreds and hundreds of hours looking, because I'm sure they weren't that limited in that respect. And they could not find a single song that combined the same similarities in that kind of constellation. So they said it was coincidental. They said it was just the vibe, just the style. But the truth was they found nothing else to show that it was common in the literature to have that combination. And they had to admit that on the stand.
Wow. So winning that must have been an amazing feeling for you.
Well, it had been a real challenge, as I say, because it kind of backfired on the other side in the sense that I think they thought that we were basically done when they eliminated our recording, but we were able to have a modified version shown to the jury. So
the underlying foundation to all of this is that music has value. I mean, real value, not just value because we like to sing it, but it also has a financial value that you can quantify and put a dollar figure on. And if somebody else wants to use your music, they're taking something that has real financial value that you can then sue them over.
That's a very fair way, and that's why they call it intellectual property. That it has a value. I mean, often we're asked to, we do a lot of other work besides litigation, and sometimes we're asked to prevent copyright infringement in terms of consulting on music that's being prepared or produced. But also, there are estates such as, the descendants and the heirs of composers, and there is a valuation attached to those musical catalogs and the works that those people wrote in terms of future income from the music, So yes, it definitely is a business. There's a business aspect to it, yes.
Well, it's been well over a year since we recorded that interview. Yeah, we suck. But the Ninth Circuit Court of Appeals sided with the lower court by stating that Got to Give It Up from Marvin Gaye was entitled to broad copyright protection because musical compositions are not confined to a narrow range of expression. In other words, the court confirmed that Marvin Gaye wins and Robin Thicke and Pharrell lose despite the multiple appeals. And from this point forward, the Gaye Estate is entitled to 50%, that's half of all royalties, from that song that used his song forever. Well, at least to the end of the copyright.
21 Kilohertz is sponsored by Audium. Audium gets songwriters, composers, and music publishers paid for the digital use of their music. If it streams on Spotify, Rhapsody, Tidal, YouTube, or is downloaded on iTunes, Amazon, or any other digital music service, you deserve to get paid the money you earned. Audium works for Metallica, Red Hot Chili Peppers, Jason Mraz, Jimmy Buffett, and thousands more. To get started, simply go to audium.com, provide your information, and collect your money. Audium. AUDIAM. Get paid for the use of your music.
All music on 21 Kilohertz is provided by freeplaymusic.com. Freeplay Music is an online searchable music library anyone can use. At Freeplay Music, you can search and license songs to use in your video, your project advertisement, your business presentation, your movie blockbuster, your video game, or your kitty cat fashion show. Anything else you could think of.
Opening narration provided by Karin Gilfrey. Need the perfect voice for your corporate videos? How about some narration for your year-end presentation? What about a scintillating voice for your in-house voicemail system? For more information, go to karingilfrey.com. That's CARINGILFRY.com.